Honors.
Good morning. You may proceed.
This case presents an important issue concerning police interrogation tactics, where the police have determined that they have sufficient evidence to arrest a suspect whom they have been interrogating in a police station for more than 5 hours. How long may they delay the arrest and the so-called telephone rights mandated by General Law, Chapter 276, Section 33A, in hopes of extracting a confession? The central issue here is the intent of the police in delaying the moment of arrest. This court has made clear that any statement obtained as a result of the intentional deprivation of the defendant's right to make a telephone call must be suppressed.
When does the right accrue? I thought it accrued at arrest. I thought we've made that clear.
Yes, it's within 1 hour of arrest. That's right.
And he wasn't arrested until 9 or 9:30?
Well, there is ambiguity there, as I was about to say. Within the rubric of intentional behavior, let me back up. There is the suggestion of an exception to this, or that the question is a little bit more complex than that. Specifically, in Dagley and Rivera, this court indicated that if there is evidence that the police have manipulated the time of arrest to delay providing the suspect his telephone rights and thereby obtain a confession, suppression of the confession would be appropriate. In other words, and this is the core of my argument that I made, I think, clear in my main brief, that it's not as simple as saying, when is the arrest, measure 1 hour from that, and beyond that. Here it's clear that the arrest occurred after the confession, and the case law is clear that where the confession occurs, strike that.
But, and I appreciate that Dagley and Rivera decided after Judge Agostini wrote his, after the motion to suppress, correct?
I apologize, Your Honor. I'm not actually, I am not clear myself about that point.
Well, I think the motion to suppress was in 2002, I think.
I can answer that very quickly, Your Honor. I have the motion to suppress was decided, is in my appendix, decided October 17, 2003. And Dagley is 2004, and Rivera is also 2004. So Your Honor is correct that they were decided after he wrote that.
So he wasn't sort of factoring them into his decision. I appreciate that. But he did seem to suggest that the police were engaged in this extended interview of your client, and that that was continuing. And while now I'm adding on the Dagley and Rivera, while the police can't manipulate, are you saying that if they take steps to complete an interview or an interrogation, that is the same as manipulating the time?
No.
As soon as they have probable cause, they need to actually effectuate the arrest?
Your Honor, I think, has seized on precisely the point, and I think that is absolutely the legitimate, correct question. I think that, and I think that this Court has recognized that in its decisions, and in Dagley and Rivera specifically. There is a distinction. I think if we're talking about a situation where the police are engaged in an ongoing interrogation, and at some point in the midst of that interrogation, they determine that they have probable cause to arrest. I am not, and there's an active back and forth with the defendant or the suspect, and this is a crucial fact. I mean, this is very fact-specific, but in that context where there's an ongoing back and forth, and there is some sort of progression in the interrogation, I submit that it would be unreasonable, and I think that this Court has already suggested it would be unreasonable to artificially expect the police to stop at that moment. As soon as they recognize we have probable cause, we must stop the interrogation, we must immediately arrest the defendant and proceed accordingly. I'm not suggesting that, and I think that's precisely Your Honor's point, that this seems unreasonable and unnatural and unworkable and unfair to the police. And I agree with all of that. What I'm suggesting is this factual pattern is different from that, distinct from that in an important, crucial respect. What we have here is the police having a first interrogation, which is in a police department, beginning at 11:50 at night, where the defendant is isolated. It's a rural, remote state police barracks. He's by himself. He was brought there by the police. There's some evidence of intoxication.
He does keep going outside and smoking
yes,
and coming
yes,
back.
Yes, Your Honor is correct about that. But it is a situation created by the police. There are certainly countervailing factors. I recognize that. But they've taken a complete statement over the course of 5 hours. Then they are handed these keynote tickets. They're brought from the defendant's wallet, and these are essentially very powerful evidence that he was in the apartment and that what he's told the police over the last 5 hours is not true. The police acknowledge clearly, there was no dispute in the record, that at that moment they have probable cause to arrest, and they're not going to let him go. And so he is truly in custody at that point. Now, they read the Miranda rights to him. They then present him with the keynote tickets. I submit that still nothing inappropriate has happened. I'm not suggesting the police should have arrested him at that point. That's not my argument. I'm saying that the police then appropriately asked him about the keynote tickets. Even though they have probable cause, I'm not suggesting they had to arrest him. He makes a few initial statements, but then once he's fully understood the significance of these tickets, this is the crucial point. He is silent. He essentially puts his head down and is silent. This happens at roughly 5:30 in the morning. Now, according to the police, this is the police testimony, he is silent from essentially from 5:30 until 7:15 in the morning. This is, as I submit, the crucial distinction here. He is silent. This interrogation has stopped.
Let me ask you, at what point did he tell the story about he went to the victim's home, that he had been invited to sleep in a chair if he needed to, and that then the victim went into the bathroom and came out naked? When did that?
That's the second statement, Your Honor. That began at 7:15. That was made in response, well, first of all, after a period of silence from 5:30 in the morning till 7:15, and only in response to the very emotional plea from the state police lieutenant Smith. Lieutenant Smith comes back into the police barracks at roughly 6:45, 7 a.m. He's not been involved in the interrogation to this point. He speaks to the two Pittsfield officers who have been involved in the interrogation, and he says to them, "Where are we?" I'm paraphrasing. "Where are we in the interrogation?" They say to him, essentially, he's close to confessing. I think they said he's close.
We're not there yet.
We're not there yet. Something along those lines. And Lieutenant Smith essentially goes in, and so. But here's the picture, the crucial picture, as far as I submit my argument. He's been sitting there silently. The police are essentially intentionally delaying the moment of arrest. The investigation is not moving forward at this point, and yet they have the basis for arresting him. And to sort of draw it into starker contrast, to perhaps make the question clearer, I would suggest a hypothetical. Could the police simply wait indefinitely, 5, 6, 10 hours, with the defendant sitting there, waiting for him to confess before they arrest him? I submit that we would all agree that at some point the police must move to arrest, or alternatively, or more clearly, if they don't move to arrest, and then they eventually wear the defendant down, or the suspect down, and get a confession, that confession must be suppressed. I think that's the issue that this court was alerting the police to, in Dagley and Rivera. The court sensed that at some point the police must act. And I submit that while perhaps this case is on the closer edge of this, I submit that this 2-hour waiting period was inappropriate. That what the police were doing was precisely what this court had predicted would be a problem in Dagley and Rivera. The police were intentionally manipulating.
What did the judge say about this hour and a half or whatever it was gap?
Your Honor, he did address it. He said that, well, he characterized, and I think it's important, and I've addressed this in my
What page is that on in his decision?
Oh,
Do you know? Okay, never mind.
I'm
That's
not
all right.
sure. I can find out. But he characterizes it as properly and promptly completing their interrogation. It's important to, I think, focus on this. I wish I quoted it in my brief. But essentially, oh, here it is. I actually have the quote. I don't have the page number. I apologize. But he says, "It is perfectly understandable why the law enforcement officials would choose to conclude their interview properly and promptly, give the defendant an opportunity to review the statement to ensure its accuracy and voluntariness, and then formally arrest the defendant." Now, Judge Agostini reasonably suggests that the telephone rights statute should not be interpreted in such a way to create artificial barriers, as Justice Botsford was talking about. I think he's sensing the same issue that Your Honor is talking about. That's a reasonable position. But what I submit is that he is inaccurate in his characterization of what actually happened here. This is not a situation where, which I described, the initial hypothetical, where the police are engaged in an ongoing back and forth with the defendant, and they learn...
Was there evidence that the defendant in this time period was reviewing his statement?
No, not from that. See,
That's earlier.
no.
Earlier.
Well, there are two statements. So, what Judge Agostini is describing didn't actually happen. He's reviewing. There's a first statement that happened that occurs from midnight to about 4 a.m., 4:30 a.m. He did review that statement. That was an exculpatory statement. I didn't have anything to do with this. I don't know any Bob. I wasn't there. Then from 5:30, the police get the Keno tickets at 5:30, and they explain them to him. From 5:30 to 7:15, Mr. LeBeau is silent. The police are interrogating him briefly. He puts his head down, holds his hands down, and stops talking.
And he says nothing for that whole period?
He says nothing for that whole period.
And they're sitting there asking him questions?
They're initially asking him questions. The record is somewhat unclear.
Does he go out and have a smoke or anything in that
He
period?
does not know. From the point that the police got the Keno tickets, they began treating him very differently. Up until that point, they had been giving him some latitude. He had gone out to smoke. Your Honor is correct to recall he goes outside to smoke. That is before the Keno tickets are brought to the police station. Once the Keno tickets are brought to the police station, the police candidly admit that they are not going to allow him to leave, and he is going to be arrested. They don't say that to him.
He's escorted to the bathroom, but they're with him.
Yes, he goes to the bathroom once with
Yes, I
escort,
remember that.
but other than that, he does not leave the room. There is no more smoking. The police ask him some more questions, but he essentially puts his head down and says, I'm not, he utters a profanity and basically puts his head down.
At that point, they've got probable cause to arrest him, you say. But they certainly want to press forward and get a confession.
Yes, they do. And I submit that that's right. And I submit that as an...
There's nothing wrong with that, is there?
There's nothing wrong with that as an initial matter. What I submit is the problem is once it's clear to the police, and at some point in that hour and 45 minutes, it becomes clear to the police
that he's not going
to talk. And we know that because the police essentially stop asking him questions at that point. They go downstairs, they don't leave him alone. One officer is there, but it's clear from the record that they're not asking him questions for a while. And it's an extended period of time. It's not 5 or 10 minutes of silence. It's more than an hour of silence. And then Lieutenant Smith comes in downstairs, not in this room, and says, where are we? And they say he's close to confessing, something like that. Lieutenant Smith goes upstairs and gives him this very emotional speech saying, and I think that's the moment when he cracks finally. And I submit
That's about when?
7:15 in the morning.
Okay.
But, Mr. Wood, I'm just looking at Judge Agostini's findings at the record. It's A11 through 12.
Okay, thank you.
The timing is a little less, I think, than you are saying. I mean, just in the sense that it looks as though it was 6 o'clock, he says on A11. This occurred at 6. That is the tickets were shown to the defendant. At approximately 6:30, Lieutenant Smith arrived. There was a discussion, obviously, and between 6 and 6:30, at some point, the defendant asked to use the bathroom and did so with escort. At 6:30, Detective Lieutenant Smith arrived, and then, he doesn't give a time, but it sounds as though somewhere between 6:30 and 7, Detective Lieutenant Smith goes in and says, "Look at me, did you kill that man?" So, maybe we're quibbling, but it's not an enormously extended period of time, I guess is all I'm saying.
Well, Your Honor, first of all, I with all due respect to Judge Agostini, my time frame is drawn from the record. I submit that Judge Agostini is not accurate. I apologize, but I submit he's not accurate. I've quoted my time frame. It comes from I can't give you the transcript. I can't quote the transcript, but on page 15 of my brief, 15 through 17, I go through the timeline and I give transcript citations. So at 5:30 a.m., Officer Bowler showed Mr. LeBeau the 3 Keno tickets, volume 10, 149, and it goes through,
okay.
and I give the transcript citations. And obviously, Your Honors will go and check the record yourselves. The important point here is that there was a significant and extensive period of silence where the police stopped interrogating. And what you have here is essentially the police saying, okay, we've hit a dead end. What are we going to do? And what I submit that they are required to do once the interrogation comes to a stop is they are required after some reasonable period, and I guess that's the difficult question, what is that reasonable period?
What do you say the reasonable period is?
I say that that is precisely the sort of thing judges should decide, but that what I think is that here, whatever that reasonable period is, it was exceeded. And most importantly, I think that the crucial question here is the intent of the police. Are the police intending to manipulate the time of arrest in order to essentially coerce the defendant into making a statement? I think that what you have here, the important factors that go into that in this particular, it's a fact-specific exercise.
Of course they're manipulating it. What do you expect them to do? If they got a guy who they just found some very important evidence on, who they think's about ready to, fess up, they're obviously going to spend some extra time.
Yes, and I think that Your Honor's...
And the word reasonable, that's an awful word. I mean, how are we ever going to define that?
Well, Your Honor...
I mean, we do have rules in certain other areas, say within an hour you got to do this, within 2 hours, arraignments got to be within so forth.
6-hour rule.
6 hours.
Yes.
I mean, if we're going to go your way, we just better set a flat-out time.
Well, Your Honor, I submit that, first of all, this reasonable, we've had this argument many times, not just with me, but with many courts and lawyers, about the difficulty of a reasonableness. Justice Scalia hates the word and talks about it in Crawford. But, of course, the Fourth Amendment uses the word, and we always talk about reasonableness of searches and seizures. It's obviously a difficult word. The fact is, it's difficult to apply. We use it all the time, and we apply it all the time. That's precisely what the common law is all about. But in this case, I think we have a totality.
I like the word egregious better. If the police conduct is egregious, then maybe you got, the defendant should get the break.
Could I ask you this question? Isn't the issue that Daglia Rivera raised is whether the police have been manipulating the time of arrest in order to avoid having the defendant exercise his right to a telephone call, right?
Right.
Yes.
So, I mean, I wonder whether that's one and the same as saying in order to try to get him to confess, because they may not be the same.
Right. Your Honor, I think that, and I actually wanted to address that. I think Your Honor has seized on something that's actually fairly important. That I don't think it's necessarily the case. You're absolutely right. In Daglia and Rivera, or looking at Daglia and Rivera, one could frame the question here as whether and I began with, the crucial question is the intent of the police. If the intent of the police is to deprive him of a telephone call or to delay arrest in order to deprive him of a telephone call, I submit that that's actually a subset of what we're really concerned with here. And I would submit that the real question is a little bit broader than that. Are the police delaying the arrest in order to improperly obtain a confession from him? Delaying the arrest because they know that at the moment they arrest him, the chances of getting a confession are dramatically reduced for a number of reasons, only one of which is that they know that once they arrest him, they have to give him the telephone rights within an hour, and that he's likely to use that to call somebody. And
But that sounds to me like your classic voluntariness analysis. Was the delay such that it caused the statements to be involuntary?
Your Honor, first of all, Your Honor is correct, I think, that there is this issue of voluntariness. I did raise voluntariness in the second part of this first argument. I do challenge the voluntariness of the confession, but I do submit that they are distinct analytical concepts. I submit that even if you disagree with me about the issue of the voluntariness of his confession at 7:15 in the morning, that because the police manipulated the time of arrest in order to keep open the possibility that he would confess, that provides an independent basis to exclude his confession. I submit that at 7:15 in the morning, it is true that as a result of a totality of circumstances, he was no longer making a voluntary confession. I mean, this is a very tearful moment. He hadn't slept for 24 hours at the moment that he finally cracked and made the confession. And again, and the interrogation had been going on for over 7 hours at that point, from midnight to 7:15 in the morning. There were 2 and sometimes 3 experienced police officers with him in this isolated police station. Again, this is a situation created entirely by the police. We have the most coercive environment possible, and it's created by the police. We have the police taking a defendant from his home or his friend's home at 11:45 at night, bringing him to an isolated remote police station, and we have them interrogating him for the next 7.5 hours. We're beginning the interrogation at 11:45 at night, where they know that he will have been
Mr. Woods, your time is up.
deprived. Thank you very much.
Mr. Capeless.
Good morning, Your Honors. May it please the Court, for the record, Berkshire District Attorney David Capeless appearing on behalf of the Commonwealth. First, to answer the Court's inquiry about the timing of the case law, the Novo and Rivera cases were decided in early to mid-2004, which was after the hearing and the decision on the motion to suppress. However, the Caputo case, which is at 439 Mass 153, had been decided earlier in 2003 prior to that hearing. And if the Court may recall from the record, in the defendant's initial motion, which was filed prior to the hearing, the defendant made no claim about the 33A telephone rights, and it was only after the hearing had been concluded and it was time to argue the case and submissions had been made, the defendant was requested to open that matter. The Caputo case made it very clear that it was only upon formal arrest that the 33A rights attached, as was indicated in Rivera, in Novo, as well as in Caputo. Very similar circumstances in which there had been a period in which there could be a reasonable determination that a custody situation because of probable cause evolving had occurred where a defendant was being interrogated. However, in each one of those cases, this Court has concluded that, in fact, the situation of the 33A rights only applied after the taking of the statement, the defendant being informed he was under arrest, and then those procedures, including the booking, were to be undertaken. I think it's also important to clarify for this Court, from my reading of the record, there was not an extended period of silence on the part of the defendant. Although Judge Agostini's findings do not make a specific reference to it, there was considerable testimony by the interrogating officers, Investigator Bowler and Detective Decker, that following the defendant's showing of the play cards, not the keynote tickets. Well, they had the tickets, showing the tickets to the defendant.
What's the difference between play cards and tickets?
What was found at the crime scene at the victim's apartment were the play cards. That's what you fill out with the pencil. Give them to the cashier, who then gives you the tickets. What was discovered at the apartment was the play tickets were there, but the tickets were not, along with what was also missing were the cash and the rings, leading to the conclusion that the person who had murdered Mr. Vincent had taken the tickets and had left the play cards. And so we also knew exactly what play cards they were, not only where they came from, but the exact numbers. And that is why we were able to determine those tickets had come from Mr. Vincent's apartment.
Yeah, the victim's name isn't on the tickets.
No,
No, but you can
but
check the
they're,
Keno
But you match
records.
it
but by
against the
checking
numbers.
with the lottery,
Yeah.
they were able to determine, because of the barcode on each one of them, not only the numbers, but exactly where they were purchased and the exact time they were
Now,
purchased.
Mr. Woods makes the point or asserts that the record, the evidentiary record, does not support Judge Agostini's findings on what may or may not have occurred during the so-called time gap. That's not your position. You say it does.
Well, I'm saying that Judge Agostini does not go into detail about what happened during that period. In fact, highlights other parts, in a sense,
But
leaves
if we
it
look at
out.
that- if we
But
look
I'm
at the-
saying if you go back and look at the testimony,
Uncontroverted testimony
yes,
by the police,
Fro-
you will
that-
see that they were doing things.
yes, they were talking with the defendant. In fact, this was the period in which there was this whole give and take back and forth initiated by the defendant. They were responding to him, in which he starts out with the talking about the I see two devils, or they say to him, we see two devils, one angel, one devil on your shoulder, which one are you going to do it? The defendant responds, you know, which one are you going to knock off? He says, how about the one in the middle?
Says that the
And he brings
defendant-
up OJ. And what am I supposed to do? He's talking with them and going through this decision process of what do I do now? He's already
think
made
we
it
have a-
clear he
I think we
understands
have
the
a question
circumstance.
here.
I'm sorry.
Mr. Wood says that the defendant sat silently for a lengthy period of time. You disagree?
I disagree. If you go back and look at the testimony, there may be periods of perhaps a minute or maybe two that the officers testified that there were periods in which the defendant sat with his hands and his head down, but there was continued conversation back and forth between the two of them. In effect, the defendant going through this conversation with them, what do you think I should do? And they don't want to tell him, but they suggest to him, well, you have options. You can start talking about what had happened. And for a considerable period of time, this back and forth is what goes on. It is at that point that Lieutenant Smith arrives at the barracks, has the conversation with him, has a brief discussion with him in which he suggests that it's his opportunity to say what happened. And at that point, he says to the defendant, did you do it? The defendant says, I'll talk to them because he has developed that rapport
Right.
with both Decker and Bowler.
And he's gotten Miranda at that point,
He had Miranda long before.
long before.
At
The Miranda had
5:30
occurred
or something.
before the tickets had been presented to him.
And then again after the tickets? And then again, right? At 5:30 when they were about to
That
confront
was
him
the
with the
first
tickets?
time.
No.
All right. When
They took the initial statement in which he gives this, later contradicted by the physical evidence in his own statement, story about the
Understand.
victim coming onto him.
Yeah.
They type that up.
So your position.
They have a period in which he gets a cigarette.
Your
They come back
position-
in, they sit down, they say, look, things are different
Your
here.
position essentially is we'll see this police testimony, which Judge Agostini didn't make findings about, that's uncontroverted, and that fills in the time gap, and that's the end of that.
Yes.
Okay.
I think the important thing when you consider the voluntariness of this whole situation, it was not merely, as Judge Agostini did find, that the defendant at all times was alert, sober, and aware, but most significantly, that in fact this defendant it was not a matter of how the police acted, how they treated him, or where he was located, but it was his circumstances as he perceived them. And I want to quote Judge Agostini because the most significant finding he made was the defendant's determination to go through with this, not his acquiescence. And I'm quoting from page 22 of Judge Agostini's findings. Quote, all the evidence points to the fact that LeBeau saw this as an opportunity to throw off the scent of the investigators. His cooperation was being used as an offensive weapon to ensure that he would not be viewed as a suspect, or as he often stated, quote, to clear his name, end of quote. LeBeau was a step ahead of the police, and as the night unfolded, it was his deliberate and conscious goal to increase his lead. His overt cooperation was the intentional effort of a suspect who wanted the opportunity to deflect suspicion. LeBeau knew precisely what he was doing. The police had their information, and they were determined to try to speak with the defendant and hopefully get a confession from him. On the other hand, the defendant himself was determined to deflect that suspicion.
How long could they have held him? At 5:30, he's been there 5.5 hours at the state police station. He obviously can't walk home. It's not near his home. He'd been there 5.5 hours. He hadn't slept. Now the police certainly had probable cause to arrest him. How long could they have held him while they kept working out, trying to get some sort of confession?
Well, that's
Or they had
difficult
to
to
arrest
answer. It depends on the circumstances. If he had, voluntarily decided to launch into a 4-hour narrative about what had happened, that I think it would be reasonable for the police to sit there and listen to him and hear what he had to say. And I think it's important, as if you look at the two statements, these were his own words that he wanted to say. In fact, it was the defendant who requested at the end of the taking of the second statement to put in that final paragraph of apology to Mr. Vincent's family about what had happened and what he had done to him. This was very voluntary. Again, it comes down to that slippery word of reasonable. But under the circumstances, this is what had happened. They were faced with a situation where they had a defendant who appeared willing to give a statement, but was balking for his own reason and wrestling in his own mind. And at some point, the police were going to have to make a decision. That was made by the defendant after being spoken to by Lieutenant Smith. And in fact, at that point, he said, "I will speak to them," referring to Decker and Bowler. Then they sat down. They talked as they had done before, talked for a while, and then composed the second statement. He read it over, he approved it, he signed it, and then asked to put in the final paragraph. And all of this was totally voluntary. As I indicated, up to the crucial point when he was shown the tickets, and he understood the significance of them as the police had already understood. He was determined and, I think, hopeful that, in fact, he would get through this evening by having simply spoken to the police, being returned to Mr. Bradley's house, and remaining simply someone who had been at the bar and had talked to the police. It did not turn out that way, and the police pursued the evidence that they had, and in fact the defendant admitted to killing Mr. Vincent, although not as the evidence showed that he did do. The defendant has asked in this case to reduce the verdict of first-degree murder, and I would only point out to the court he bases this on the suggestion of intoxication as being a significant factor in this. I would point out to the court that the physical evidence and the defendant's own statements point out that, in fact, this was not only a vicious but a wholly brutal crime that was carried out for the most base of motives, that to steal money from Mr. Vincent. As far as the defendant's intoxication, I would point the court to the very clear evidence of the videotapes from inside Charlie's Tavern, which show the defendant at closing time, approximately an hour from the approximate time of the murder, clearing off tables, picking up empty glasses and empty bottles, putting them on trays, carrying them into the bar, helping to clean up the bar, not dropping a single one, not stumbling, very clear in what he's doing.
I couldn't agree more with you that videotapes can be very helpful. And by the way, do the state police now have videotaping equipment at their barracks?
Your Honor, at our expense using forfeited funds, I have provided every police agency in Berkshire County with state-of-the-art audio-visual equipment, which they are using, and in fact, we've trained them on it.
We have the videotapes, or we will have them.
Not of this.
Well, of the tavern.
The tavern.
Of the tavern.
Yeah.
Yeah.
This case
Looking
was,
at the clerk, and she
this
says
occurred
yes.
prior to the D. John Batista case, although the decision was in April of that year, and the sanctions
but
of
the
D. John
tavern
Batista
tapes
was
are
applied in this case.
The tavern tapes are different.
Yes.
Yeah.
The tavern tapes show the defendant there. They also show Mr. Vincent as well.
All right.
If the court has no further questions.
Thank you very much.
Thank you, Your Honors.